You had to recite remorse. Wait a minute. When I said that you had a certain amount of remorse, I was mistaken. The court determines that maximum imprisonment is needed. So it's 11 years on count 1 and 11 years on count 3. Before a jury trial starting February 5th, 2019. On February 8th, 2019, the jury returned its verdict. The verdict was guilty in count 1, aggravated burglary, felony 1, with a firearm specification, both a 3-year and a 1-year. Guilty in count 2, aggravated burglary, felony 1, with the same 2 firearm specifications. Guilty in count 3, aggravated robbery, felony 1, with the same 2 firearm specifications. Guilty in count 4, felony 1, with the same 2 firearm specifications. Guilty in count 5, abduction, felony 3, with the same 2 firearm specifications. And guilty in count 7, which I renumbered for the jury as count 6, of carrying concealed weapons, a misdemeanor of the first degree, the jury determining that they did not find beyond a reasonable doubt that the firearm was loaded or for which ammunition was ready at hand. On that date, I found the defendant guilty in count 6, the actual count 6 of having weapons while under disability, a felony of the 3rd degree, and I found the defendant guilty in count 7 of carrying concealed weapons, a felony of the 4th degree. The court did refer to the defendant for an updated criminal record. The court previously sentenced the defendant to prison and at that time had a full pre-sentence investigation done. The Adult Probation Department did provide an updated criminal record dated February 21st of 2019, and the record, not only the pre-sentence record, but the DRC shows that the defendant was released from prison on my last sentence of him on November 15th of 2017. The court also has received victim impact statements from the victim, Arturo Gonzalez Hernandez, and Ms. Martha Murillo. The defense has filed a motion for new trial, and it was based upon the defense's desire, and this motion was made during the trial, and as a motion in limine, it was covered before trial started. The defense wanted to cross-examine him on the application for a U visa, and the court ruled that the defense could not get into that. I ruled that before the trial. Nothing that happened during the trial changed my mind about that while the trial was pending, and as I sit here in retrospect, the court is of the opinion that my ruling was correct, and in fact the court did not hear anything that I would consider an embellishment, and in fact I'm not sure he even qualifies for a U visa under the facts as he testified to, but that's for the federal immigration judge to make that determination. but the court's opinion of the evidence was that Mr. Gonzalez testified consistent with what he told the police, and that court didn't see any exaggeration or embellishment in his testimony on that topic. Actually, had he embellished, it probably would have been a felonious assault charge added to this, and also I would have found the kidnapping was such that that would be a separate animus, and that I would sentence separately on that. So the motion for new trial is denied. And is there any reason not to proceed to sentencing at this time? Mr. Williams?
No, Your Honor.
You may address the court first.
Yes, sir. I was aware a sentencing memorandum was submitted by the defense prior to today's hearing. I believe the court's submission of the issue of merger largely mirrored what the defense had submitted as far as murder charges. I would just briefly address the issue of murder of counts 6 and 7, aggravating weapons under disability and carrying a concealed weapon. While there are certainly circumstances and case law to support, at least case law is actually cited in the state's sentencing memorandum, where these two offenses have been found not to be subject to the merger doctrine. In those situations, I think it was more so speaking to an individual who actually acquires a weapon prior to commencing a criminal offense, and obviously uses that weapon in the course of a criminal offense. I think here our situation is distinguishable in that Manson Bryant was convicted essentially under an aider and abettor theory. There was certainly nothing to indicate that he took part in the actual acquisition of the firearm by Mr. Bynes. There was nothing to indicate that he actually physically possessed that firearm throughout the course of the crime that was committed here. For that reason, we feel it's distinguishable. The so-called, essentially the possession of the firearm is all part of the continuous course of conduct, and Mr. Bryant was found guilty of those offenses based upon being aider and abettor to Mr. Bynes in the commission of this act. As the sentence, Your Honor, obviously the court has at its disposal here, given the number of offenses, the firearm specifications, the court can craft a sentence here that would essentially keep Mr. Bynes in prison until he's at ripe old age. But we would only note that retribution is not the only goal of the legal system. Rehabilitation does carry equal weight, and a sentence that would essentially prohibit Mr. Bryant from being afforded any meaningful opportunity to redeem himself and live a law-abiding life would not be in line with the purposes and principles of sentencing. We are asking the court to consider a 10-year aggregate sentence. We feel that would not demean the seriousness of conduct here, and not demean the essentially role as a aider and abettor that Mr. Bryant was found guilty of here. We feel that sentence would be commensurate with sentences that have been imposed by this court for similar crimes and against similar offenders. The court is aware that the principal actor here, Mr. Bynes, did in fact receive a 12-year sentence, and we feel a 10-year sentence is in part of the role that Mr. Bryant was found guilty here in this particular offense, and such a sentence would provide him the opportunity to live a meaningful life and improve himself in the court that he was capable of rehabilitation. Thank you, Your Honor.
Manson Bryant, the law allows you to say whatever it is you want me to consider before I sentence you. Is there anything you want me to know?
Yes, sir. Your Honor, I know you very well aware of my history. I made a lifetime of bad decisions. And those bad decisions have caused pain for a lot of people in my family. For that, I am truly sorry. Most of my bad decisions have been driven by my addiction to drugs, and to do whatever I can to continue to get high. My ability to stay clean has had me to spend most of my life in prison. There's no way for a person to live. That's no way for a person to live. And it's not how I want to finish my life. Despite the circumstances of my upbringing, I understand that I can't continue supporting others for my actions and my behaviors. I become jaded toward court legal system by having this trial was an honest and open hire for me. I have never gone to trial before. I have a newfound respect for the efforts of the attorneys, judges, jury, and go in living as giving the accused person the opportunity to have the case heard. That's all I wanted to ask. I am thankful for the opportunity and the court by the day in court, and I respect the decisions that the jury has made. I don't have the power to end the cycle of incarceration, and all I ask for you to give me a new opportunity to still make something out of my life, sir. Oh my God, please, sir. I'm not that person, sir. You have to do it. I've been for you one time. I respect you. I respect the decision that you made. Thank you.
Do you have any witnesses to present?
No, Your Honor, thank you.
All right, let me hear from the state.
Thank you, Your Honor. Just in reply to the merger argument, the state also filed a sentencing memorandum that does deal with the merger issues. And count 6 had brought up the facility and hearing facility weapons, count 7. Through the case law, they have separate animals and they do not merge. Goes back to your house to record many districts. The acquiring versus the concealing of the weapon are separate animals, regardless of whether Mr. Bryant acquired it or Mr. Bryant acquired it. Mr. Bryant was aware of that. They had it in the condo well before they left to do this. They were aware of it, and the need to conceal it makes it different as well. So we do feel there are separate animals, and there are no reason that those would merge even in this case. Also, there was an argument made that there needs to be, well, I'll get that. For sentencing, Your Honor, obviously this court has heard in detail the facts of the case. I don't want to go over them extensively, but just looking at the factors in this case, they are laid out in the sentencing memorandum. However, just so the record is clear and others can hear, obviously the victims, Mr. Gonzalez and Mr. Morello, both suffered serious psychological harm. Mr. Gonzalez was present as people unknown to him enter his home without permission, terrorize him, steal from him, as the court has made reference to, pointed a gun at him, pushed against his forehead, pushed him back, threw a blanket over his head, continued to move the gun around his body, pinning him into a cage as he was punched in the head. Even when they left, it left a lasting impression. The point that he left that location, he no longer lives there, he didn't feel safe or comfortable there. He was renting that room with Ms. Morello. She has also had concerns as she came home and Mr. Bryant and Mr. Bryant were leaving. She was running late. Had she not been running late, she could have walked into that situation and she had a young child with her. So she also had psychological harm and what could have happened, what did happen to her friend in her residence. We also had serious economic harm. The restitution request for $1,298 from Mr. Gonzalez. He worked very hard for what he has, and those were what he considered all of his valuables. The laptop that he had just purchased, all of the cash he had, jewelry that he had been given by a friend or purchased himself. Those things can't be, we give them a monetary value for restitution. You can't replace the actual items that have sentimental value. Just the feeling of being violated in that manner. Obviously, the defendants were part of organized criminal activity. We had convened and gave information to Mr. Bynes. Mr. Bynes to had Mr. Bynes come with him, so there would be two, and there would be sort of a heavy person as well as a person with a gun. The individual was present to over one or member else to be in the trailer at that time. So they all work together to facilitate the offense, and the knowledge that Ms. McKeon had regarding Mr. Gonzalez transferred down, so the knowledge of with the victim and the relationship did facilitate the offense. When we look at recidivism factors, there's even a larger concern for what we're looking at. The defendant had a history that includes numerous juvenile adjudications going back to 1999. I won't go through all of them, since they are laid out in the memo, but I will point out that in 1999, he already had domestic violence and a felony theft. 2000, more thefts, and F2 burglary. 2002, we have assault. 2003, multiple thefts and falsification, already showing crimes of deception as well as violence. 2004, there are 2 separate felony drug abuse cases and an assault case. He becomes an adult in 2005, and his history of adult criminal convictions begins. Again, just pointing out some negative highlights, I suppose. In 2005, we have more thefts, assault, resisting arrest, probation violations. 2006, there are more thefts. 2007, more thefts. 2008, thefts. 2009, felony receiving stolen property. 2010, and that was the first prison sentence. 2010 was theft with probation violation, and also attempted robbery at 4. That was another prison sentence. 2012, multiple thefts, assault, felony attempted receiving stolen property, felony assault with a probation violation. 2014, felony receiving stolen property, felony robbery, to prison on those. He gets out of prison approximately November 15th of 2017. Then we have 2017 theft, and in 2018, while he got most embarrassing as well, attempted vandalism in April 2018, and theft in July 2018, and this incident was also the beginning of July. Also, as a juvenile, went to Department of Services, which you sort of think of as juvenile prison. He has 4 prior prison terms as an adult on 5 separate cases. He was placed on 3 years post-release control when he was released in November 2017. So he was on post-release control at the time of those offenses. As of today, he has 623 more days on post-release control. And those days he has, and he is not responding favorably to sanctions previously imposed by probation violations, contempt charges, parole violations, and obviously he has continued to commit crimes, not stopping in that form. And the state of our really is no genuine remorse. He didn't take responsibility. And today, if I heard correctly, he apologized to his family, but not to the individuals he hurt, specifically in the trailer and the trailer's owner. There was also a comment made about one of the co-defendants got in similar crimes and similar defendants, similar sentences. However, I would mention the court is aware, that doesn't mean numerical comparison. It specifically means looking at all the factors and purposes and principles, which this court does in every single case, to look at those cases to what should be done in that case. Numerical comparison has been found not to be appropriate throughout this district and others. So we do feel that prison is obviously consistent. There's a presumption for prison on both counts 1 and 3. And there are gun specifications on those as well. We feel that any sentence that this court does render should be prison and there should be consecutive sentences. The serious nature of what occurred in this case, we need not to do prison to consecutive sentences. We also need to protect the public from future crimes, as well as to punish the offender. And what we did was quite horrible and horrendous for those involved. In addition, as stated, he was under post-release control, and his history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crimes by the offender. So based on all that, we do feel that prison is appropriate, that all prison sentences should be consecutive. And we feel at least 20 years would be appropriate at a minimum. We would ask for forfeiture of pistol and ammunition. We would ask for restitution to Mr. Gonzalez in that $1,298, and as the court is aware, PRC would be mandatory at 5 years. And that would be the state's recommendation.
Does the state have any witnesses?
No, Your Honor, the victim impact statement that you received is not issued.
The court has considered the record, the oral statements made, the victim impact statements, the trial testimony and evidence, the pre-sentence report from several years ago, the updated criminal history, my conference in chambers with counsel and probation, and statements of the defendant and the defendant's counsel. The court has also considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish the offender, and to promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local governmental resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've considered the recommendations of the parties, including the sentencing memoranda. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victims, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in Divisions B through E of Revised Code 2929.12. In that regard, there are factors making the offenses more serious. The victim suffered serious psychological and economic harm. And I'm talking about Mr. Gonzalez. I believe he needed psychological treatment as a result of this. The economic harm was substantial. The Murillos suffered significant psychological harm for the home invasion that occurred as they arrived at their place of residence. The offense was committed as part of an organized criminal activity. There were 3 people involved in this. There are no factors making the offenses less serious. In terms of recidivism, the offenses were committed while on post-release control from the previous time that I sent the defendant to prison for a crime of violence. The defendant has an extensive previous criminal history and history of juvenile delinquency. He's been to prison 3 times on 4 cases. He's got 9 prior crimes of violence before this case. He's got 11 instances of probation violations, resisting arrest, obstructing justice, and contempt of court, and numerous convictions. He's been arrested on 4 other crimes, plus this case, while on post-release control. The defendant was placed on PRC on November 15th of 2017, a 3-year period, and yet committed this offense less than 8 months later. There's a pattern of drug or alcohol abuse, and the offender refuses to acknowledge a problem or accept treatment. There's been a rehabilitation failure after previous convictions and delinquency adjudications, and a failure to respond in the past to probation or post-release control. The court determines that the offenses were committed under circumstances very likely to recur, and the court determines to make recidivism less likely that the offender shows a certain amount of remorse. The court determines, though, that the defendant poses the greatest likelihood of committing future crimes. On felony 4, the CCW, there is no presumption in favor of community control because of the PRC violation and the prior prison terms, and because it was possession of a firearm. On the 2 felony 1s, there is a presumption in favor of prison, and there is not a lick of evidence here by which the court could override that presumption in favor of prison. The court determines that prison is needed to protect the public from future crime, that a minimum sentence would demean the seriousness of this offender's conduct. The court believes that consecutive sentences are necessary to protect the public and punish this offender. They would not be disproportionate to his conduct and the danger he poses. That the crimes were committed while on post-release control, that the harm is so great or unusual that a single term would not adequately reflect the seriousness of his conduct, and his criminal history shows that consecutive terms are needed to protect the public from future crime. Accordingly, it is the sentence of this court, Anson Bryant, that you serve a period of incarceration in state prison. The court hereby terminates your post-release control, and I am imposing the balance through November 15th of 2020. I believe that comes up to 623 days according to the DRC's calculation. The court sentences you to prison on count 1, aggravated burglary, felony 1, for 8 years, and 3 years on the firearm specification. The court sentences you on count 3, aggravated robbery, felony 1, to a period of incarceration in state prison for 8 years, plus 3 years on the firearm specification. The court sentences you on count 6, weapons under disability, felony 3, for 36 months. And on count 7, CCW, felony 4, for 18 months. The court makes the 2 weapons charges, count 6 and 7, concurrent with each other and concurrent to all of the other charges. The offenses, however, the court makes the 2 F1s consecutive with one another. And therefore, the order of serving your prison time would be PRC time first, followed by the gun spec on count 1, followed by the gun spec on count 3, followed by count 1, followed by count 2, for a total of 22 years with credit for 231 days. The court determines that you have or will have the ability to pay restitution. Actually, you know what? Remember that you had to sign. Wait a minute. When I said that you had a certain amount of remorse, I was mistaken. The court determines that maximum imprisonment is needed, so it's 11 years on count 1 and 11 years on count 3.
You racist bitch! You ain't shit! Nancy, calm down, bro. Let me up the courtroom, man! Take him out. Hey, just take him out. Just take him out. Get out of
You
here.
racist, that shit bullshit. You racist as fuck.
Hey, take him out, please. Please take him out, please.
I love you, bro.
I love you, man. Don't
I
worry.
love you, Chad.
So that's 28 years with credit for 231 days.
I don't want to hear it, man. Let me out.
Let's go.
Let me
Hold
out.
on.
I don't want to hear it.
Go.
Let me out.
Let him go.
Let me out.
Let's take him out.
Let me out, man. I swear to God, turn up in this bitch.
Does counsel waive the
Oh my God, kill me. Let me
Does
out.
counsel waive the client's presence for
Let me
the
out.
remainder of the
Let me
advisements
out,
I
man.
have to
Take me
give?
back.
Yes, Your Honor.
All right, you can take them.
Gangster, bitch. You are a gangster. Hey, thank you, Dennis. Thank you, sir.
Court determines that the defendant has shown no remorse whatsoever. I was giving him remorse, a certain amount of remorse in mitigation of the sentence. The defendant has shown me that he has no remorse whatsoever, and therefore the court determines that maximum imprisonment is needed. He poses the greatest likelihood of recidivism. So I believe I stated that restitution in the amount of $1,298 to victim Arturo Gonzalez, judgment rendered for that amount to be monitored by the Ohio Adult Parole Authority, payable through the clerk of courts. Defendants to forfeit all items in the specification, being the pistol and ammunition, to pay the costs of confinement, prosecution, supervision, treatment, and court costs. Upon the defendant's release from prison, it will be on a mandatory non-reducible period of post-release control for 5 years, subject to the jurisdiction and control of the Ohio Adult Parole Authority. You can return him to prison for up to 9 months for any one violation, and up to 1/2 the original prison term for all violations in the aggregate. All of that time is part of the sentence. Should the violation of PRC be a new felony, the judge in a new felony case, in addition to sending him to prison on the new case, can send him back to prison on this case for the greater of 1 year, or whatever length of time remains unexpired on that mandatory non-reducible 5 years. All of that time is already part of the sentence. The defendant may be eligible to earn some credit against time to be served on the non-mandatory portions of this. The non-mandatory portions would be counts 1 and 3, the mandatory portions being the PRC and the 2 gun specs. The credit is capped at 8% of time to be served. As long as the defendant owes court costs, stake and block his motor vehicle registration, court opposes shock incarceration or intensive prison program, bond if any is released. The defendant is ineligible for judicial release, and the time period for counting judicial release eligibility does not count during the mandatory times, which would be the PRC and the 2 3-year gun specs. Anything else?
Not from the state.
Nothing, Your Honor, thank you.
Probation have anything to say? Good probationer for you?
Yeah, I'm sure.
All right, we're adjourned.